but the cold that I have is very stubborn, so I hope that you can hear me anyway. I chose this topic, the end-of-life debate in Italy, some ethical and legal concerns, because in Italy there is a huge debate about it, both at the ethical and legal level. Nowadays there is the possibility of prolonging biological life of individuals both in persistent vegetative state and persistent or permanent vegetative state and in their terminal phase. In this situation affects many persons nowadays, and in this context the decisional autonomy of the single individual can conflict with the opinions of other actors like family members or the physician. And in this context, many ethical questions arise. To what extent can decisional autonomy prevail? In those cases in which the person has not expressed his opinion with reference to euthanasia or assisted suicide and can no longer express it, what are the decisional powers, rights and duties of other actors like family members and the physician? How do the decisions concerning these topics affect relationships? I'm totally aware of the fact that in some legal system the law has given prompt and adequate answers, but this is not the case of Italy. In addressing the link between these bioethical issues and their influence on the moral attitudes of the individuals, I aim at showing the different ethical positions and the response of law. So in particular, I seek to survey the current state of affairs, to analyze emerging trends and problems in Italy, consider the critical case in the path towards the implementation of individual freedom. So we take into account the Italian bioethical debate as well as the Italian legislation in this topic, including recent leading cases decided by the Italian courts. Why is Italy a critical case? Because of the particular approach that we have to bioethical issues. We have what have been called or termed a bipolar or dichotomic approach to bioethics, which influences the ethical but also the legal level of the debate, especially when it comes to the formulation of legal acts. With this bipolar approach, I mean that there are two parties involved in the discussion, but they have extreme different opinions, and they cannot find a good balance or a good compromise to implement and formulate legal rules. Which can be adequate for a pluralistic society. And we speak in Italy about Catholic bioethics versus lay secular bioethics. So of course I have to clarify the ethical perspective I deal with, because as I come from Italy, I belong to one of these two parties. I will consider the relevance of the decisional autonomy from the viewpoint of a secular bioethics. According to this concept, all human beings who are adult and aware of what they do have equal dignity and capacity to self-determination. And this means that individuals have the right to decide freely when it comes to decisions and intervention of the body, and the only limit is represented by the non-violation and non-damage to others' dignity. So in this view, the self-determination principle is a meta-principle. It works on a moral level, defined procedural, and it helps to solve the conflicts among the other substantial moral principles, like beneficence, malfeasance, justice, and so on. The self-determination principle is arguably the principle which holds everything together and enables the balancing of different interests and values in a pluralistic society. This ethical approach is founded and presupposes a meta-ethical background based on non-cognitivism and non-objectivism. In this sense, this secular lay refers to the method that guarantees the coexistence of different moral perspectives and codifies the principle of tolerance and responsibility. So what are the questions arising from a legal and ethical point of view in the end-of-life debate? Should family members and the physician intervene in the decision-making process? If so, how? Is it a decision for or with the patient? And is law an adequate tool to implement self-determination? How can law regulate such sensitive topics? The general framework or the decisional autonomy in the end-of-life debate, some general considerations. We can say that nowadays the decision-making process is no longer unilateral, so physician-centered or external to the patient, family-centered, because this process is overlapped by informed consent and the possible existence of a living will. These two tools, informed consent and a living will, have caused a change of paradigm in the physician-patient relationship. As for the category of terminal patients, if they are able of expressing a consent, for example, to assisted suicide, there is or should not be place for a physician refusal in accordance with the principle of self-determination. This is also valid for patients in permanent vegetative state who have expressed their will to discontinue medical treatments in a living will. What is then the role of the family members in this general framework? They may support the patient in his decision, but they cannot decide for him, her, or discuss possible solutions with the physician without express consent of the patient. This again can be explained on the basis of the right of the individual to decide what is in his best interest, what quality of life does he/she wants, and what personal information is/she willing to share. If this is the general framework, there are still many unsolved problems concerning these topics or these aspects in Italy. And as I said, this is to trace back to this bipolar approach, which, so the difficulty in achieving an agreed solution at a moral level of the discussion makes it impossible to formulate legal rules in some hot fields, or leads to inadequate legal instruments as a result of a vain attempt to reach a compromise. So what is the legal response to ethical problems in Italy now? In Italy, the debate on the regulation of a living will has been very heated, and the dichotomic approach to bioethical issues made it difficult to find a balanced agreement. The result has been a standstill in the lawmaking process for a long time. In July 2011, the bill provisions on therapeutic alliance, informed consent and advance directives discussed and approved by the Senate in 2009 has been approved by the House of Representatives. I will discuss the problems of this bill later. Previous to this act, there was no legal vacuum. Indeed, there are different international and European legally and non-legally binding rules, which have also been mentioned by the art professor, which also apply to the Italian legal system. And the general trend emerging from these legal documents places individuals in a new web of relations and responsibilities, as they give particular recognition to the principle of self-determination in the sense discussed above. Although not explicitly mentioned, the principle of self-determination is also anchored in the Italian constitution, and so the implementation of informed consent and advance directives requires accordance with the constitutional framework and international European normative acts. Keeping in mind this is an important starting point for the criticism to the new bill I will discuss in a few moments. Before going into the details of this bill, I want to speak about two cases, two recent cases that have been decided by the Italian courts, which show how this dichotomic approach is also present inside the institutions, in the sense that we have judges and courts who are deciding cases in accordance with the legal framework I discussed from the international and European level, and on the other hand we have the parliament and the government going in another direction. So the first case is about a woman who has been in a permanent vegetative state for 17 years, from 1992 till 2008, and she died when her father obtained from the court the right to discontinue artificial nutrition and hydration. And this was a very long battle, and it has been a paradigmatic case for many reasons. It served as the battlefield for the confirmation that the physician-patient relationship and the related decision-making process are not unilateral. And it also showed that the end-of-life debate could no longer be relegated to a moral level of discussion, rather it needed a more incisive legal approach. The question is, what kind of legal approach? The second case refers to a person who has been in a terminal phase. He was diagnosed with muscular dystrophy as a teenager in the early 1960s. The disease progressed, and in 1997 he became unable to breathe on his own. However, he was capable of expressing consent to or refusal of medical treatments, and did not need a third person as legal representative. For a long time, Pier Giorgio Welby, this was the name of this person, requested to discontinue medical treatments, but this request remained unheard. Because the main reason for not supporting his request was the risk of being indicted of murder, as in Italy euthanasia and assisted suicide fall into this category of criminal acts. And indeed, the physician who decided to stop the mechanical ventilation of Welby was later tried and acquitted of a killing on demand charge. In both these cases, El Juan Englaro case and Pier Giorgio Welby case, if we look at the decisions made by the courts, we see that they decided and argumented in totally accordance with what has been stated at the international and the European level, and also the definitions that they give of artificial nutrition and hydration is totally in line with the definition that has been given by the World Health Organization. We will see that this is a very important point, because the new law, the new bill I will discuss, is given a different definition. So before treating the bill, just one other aspect which is good in the Italian law at the moment, which is a law that has been approved in 2004 and introduced in our system, an institute called supporting administration. It's a broader institute than interdiction and inhabilitation, so a broader category of individuals can benefit from supporting administration. And this institute is intended to meet the individual's needs in those cases in which they suffer from psychological or physical infirmity, either total, partial, or temporary, make it impossible for the person to act autonomously. So people like El Juan Englaro, Pier Giorgio Welby could have chosen to be represented by a supporting administrator. And if there is no designation of a supporting administrator, the judge can decide to designate one. And he has to choose among a list given by the law in which the privilege is given to the family members. So this law assumes that family members are those who know better the person, the weak person, and in this sense it's given privilege in the decision-making process to family members. This is the framework till here, but what about advanced directives? After 3 years of ethical and legal battle, the House of Representatives has approved a bill which regulates informed consent and advanced directives, so in July 2011. The bill is not the result of a balanced compromise between different moral perspectives. It is rather the paradigmatic example of the use of law as a tool to impose choices and determine moral values. According to this bill, the advanced directives cannot dispose on artificial nutrition and hydration. So cases like El Juan Englaro, who had expressed the will to discontinue these medical treatments to the father and to friends, could have not stated this will in these advanced directives. And they are defined, artificial nutrition and hydration, as ordinary measures that the physician owes the patient in accordance with his general duty of care. According to this bill, the advanced directives are exclusively kept by the physician and they are valid for 5 years. These advanced directives do not apply in urgent cases and they are not mandatory. The physician must take the advanced directives into account, but he is not obliged to apply them. This bill poses serious ethical and legal problems. From an ethical viewpoint, the bill is a good example of a persistent tension in the relationship between morality and law, and the bill is ideologically connoted and this is not explicitly declared. And as for the legal questions, the bill involves two main problems. On the one hand, it is unconstitutional and it violates the international and European legally binding acts on this topic, as it fails to give the proper recognition to the principle of self-determination. On the other hand, the bill fails to coordinate to the act on supporting administration, as it totally cancels the role attributed by the letter to the family members. So, some conclusions. In those cases in which family members are directly involved in the decision-making process, according to these situations in the end-of-life debate, due to this bill, they cannot decide with the ill person, as the decision will be taken by the physician. And in those cases in which the family could have decided according to the act on supporting administration, it is now the physician who decides. So we have come back to a paternalistic model of physician-patient relationship. And if we take into account these two processes, these two decision-making processes, deciding for and deciding with, I cannot find, of course, good arguments for the decision-making process for, but I can still find some arguments for the good arguments for the decision-making process with. In this decision-making process, the family is involved because we assume that they know better the ill person, and that the ill person has expressed his ideas on what's going on if he would find himself in a persistent or permanent vegetative state. What is requested by from the family, from the legal representatives, is that he would be able to his task is requires a great sense of responsibility, and especially in those cases in which there is no previous expressed will. It is a hard work to make decisions regarding the best interest of represented persons, and what is requested is that they can act reasonably. What I mean by that is that a person is reasonable insofar he is aware of his own intellectual, emotional and moral prejudices, and he is able to evaluate and balance interests of another person in the same way he evaluates his own. This should also be valid for the physician, if he could still decide with the patient, but due to the new bill, he is requested to decide for, so he will, in short, play God, and as his decision will not be based on the patient's will, but rather on the physician's technical knowledge and on his personal conscience, which, although important in the physician-patient relationship, they are not the adequate measuring instruments for moral evaluation on the quality of someone else's life. A conclusion on law could enforce the respect for the interests, beliefs and needs of the patient if it is not used to impose one moral perspective. Law can be instrumental to balance conflicting interests in these topics only if it works, as Herbert Hart used to say, as a choosing system. And I quote, this choosing system guarantees to predict and plan the future course of our lives within the coercive framework of the law. It guarantees, in this sense, the minimal standards for allowing moral values to coexist in modern pluralistic societies. And the dichotomic approach characteristic of the Italian bioethics is of no help because the two contrasting positions are too rigid and no compromise or balance can be adequately reached. Thank you very much.
Okay.